Hello learners, welcome back to our course on Law and Justice in a Globalizing World. So today we have Dr. Srinivas with us. Today he is going to give more insights on the impact of globalization on human rights regime. In the last video he mentioned about how the development issues has brought with it several impact on the realm of human rights. So here he is going to discuss some particular incidents. Dr. Srinivas, can you tell us more about the displacement land acquisition issue which you mentioned in the last video?
Yes. So, the way I discussed with regard to how globalization works, one of the important facets of globalization is that in terms of narrowing down the nation state borders, that is kind of going against the Westphalian notion of a state. So, therefore, there is a reduction in the sense, narrowing down of the state borders in all practical purposes. But what is exactly happening on the ground is that yes, the global movement has been happening, but in a kind of a selective manner. For example, if you look at it, the movement of the capital from one part of the world to the other by way of investments or by way of goods moving from one place to the other. So, in the process of the movement of this capital and economic transactions that are taking place, they seem to be having serious implications on the ground to large sections of people, and this exercise of economic transactions are taking place in the form of in the name of a development, where there is a possibility of many of the developing countries or underdeveloped countries are inviting large scale investments. So, when this investment and development go together, there are certain implications on the ground. Examples being, for example, for the large scale investment purposes, either for the purpose of mining or development projects, you need land and other resources. So, therefore, in accordance with the domestic law or by bringing certain measures at the domestic level, states are facilitating for the purpose of this development investment, land acquisition and other measures. As a result of that, the people who are either owning the land or depending for their livelihood on the resources over that land are being displaced. Now, it has multiple implications to it. Those who really own the land are being deprived of the land. Those who do not own the land but depend on for their livelihood on the land or land related activities are being displaced from it, and people are physically getting displaced from one place to the other. So, all of them really have serious implications for their rights. These rights are protected as part of international law, and also these rights are protected as part of domestic law of various countries. So, what is happening is that most of the states are facilitating by changing or bringing in certain changes in the domestic laws of these countries to facilitate this, which has direct in violation of the fundamental rights or rights or human rights which they have been holding for generations. So, therefore, and as a result of that, if their concern is not being addressed, it is also leading to some form of a resistance, which also is leading further round of human rights violations. For example, there are protests, there is a mobilization taking place, and there's general civil and political rights also getting affected as a result of. So, there is at multiple levels the rights are getting affected. So, therefore, they need to be taken into consideration, and the examples are very many. For example, in the context of India, it was Narmada Bachao Andolon which talked about displacement, which in fact brought the whole agenda of development to the World Bank to relook at the whole process to address the compensation and displacement issues. Several issues like in the recent past also Vedanta and others. So, all of them have and added to that is also the question of environment, the implications that environment might suffer because of this development. So, what needs to be understood is that from the point of view of globalization and its relation with human rights, we need to look at it that how really globalization, if it has positive implications to it, is it that it is happening across the board or is it selectively happening? So when it happens in selective manner, it looks like it seems to have negative implications to other dimensions. So these need to be taken into, and that can happen only when you approach the issue from the human rights perspective or the rights perspective of the people who are getting affected, because development sometimes is a neutral understanding it. Unless you have the dynamics that undergo as part of the development, you will not be able to capture what really happens to the other side. Otherwise, it more can be looked at from the point of view of GDP and other aspects.
Correct. So it's interesting that you brought it that the development agenda should go in hand with the human rights framework that exists. It's also interesting that you brought in Narmada Bachao Andolan case. Isn't it surprising that we had the World Bank to relook at it instead of addressing the displacement issue at the national level, when the domestic framework of human rights, shouldn't they be protecting the displaced people?
Yes, now it is a complex web of legal issues involved in it. Now what is happening is that probably the domestic legal systems of most of the countries where this investment is being invited probably are fairly effective, or could have been fair constitutional measures would have been there. But what is happening is, as part of this larger what you call as a globalization process, there are certain fundamental or important changes taking place at the international level as part of international law. Now, in accordance with its international obligations, many states are in fact bringing in changes at the domestic level also, but for the purpose of complying with its obligations at the international level. So, it is not that something that international law and domestic law are operating at independently from each other level. No, it is not really that. Almost there is a kind of a continuity between what happens at the international level as part of international law at the domestic level also. So, yes, there is a possibility of certain measures can be taken at the domestic level, but it is very difficult to take any measure against a state's international obligation. So, maybe it was the case where there is a kind of a difference between what you call as a domestic law and international law, but it is difficult to have that kind of a two different system, because there has to be a continuity, because the states are accepting their international obligations as part of international law. So, if you are taking a measure, certain measures from the point of view of domestic law measures, even if the individuals approach the institutional mechanisms through domestic law, but that are those are more or less what you get from that process is more or less what is there broadly in a uniform way at the international level and at the domestic level.
Correct. I completely agree with you with your response. So now, if we look at otherwise, we have what about the distinction that exists among the international law itself? Like, for example, on the one hand, if you look at the trade regime, we have a multilateral organization with a robust settlement system, and also on the other hand, in investment regime, we have investor-state arbitration, and they almost are very effective. In the sense, it even disproves Austin's statement of international law being weakly enforced, right? But on the other hand, we have various human rights instruments adopted at the international level, whereas any violation of these instruments cannot be resolved with the same rigor as that of a trade or an investment issue. So, what do you have to say for this?
Yes. Now, that is a little deeper question with regard to the how international law evolves in general, and how it evolves from a particular discipline to the other, or particular aspect of international law to other. It is true that in the case of trade and investment issues, there is an effective dispute settlement mechanism with certain consequences if the state does not comply with it. Same is not the case with the broad spectrum of international law dealing with human rights, with environment, probably with refugees. Yes, that unevenness is part of international law now. So, therefore, you do not find a kind of a world court on human rights. Really, an individual can directly go and approach, get remedies for the human rights world. There are regional mechanisms which are there in Europe, which are there in Latin America. But interestingly, some other developments are taking place. Just to give an example of it, but of course, it is not a great example now. The way alien tort statute was used by some of the people in the United States. Now, an interesting feature of this act is that it is a domestic law, But for some reasons, because it is one of the oldest statutes of the US legislation, and now some people used it, foreigners, non-US citizens, sued some of the corporate entities who are operating in Nigeria and other places, especially I think it was a shell company, oil company, on the ground that the US legislation can be made applicable extraterritorially. For example, if the corporation is registered or its office in the United States, even if the dispute did not arise in the US or nowhere related to it, but the individuals can claim compensation or file a suit against the corporate entities. Now, several cases were filed involving this legislation. But surprisingly, what happened in there is a dispute case called Kiobel case. After that, the things have changed. In fact, the court held that there has to be at least a kind of an active connection between the cause of action and the United States territory. So, basically the extraterritoriality has been narrowed down. So, they say that the primary premise on which the US makes a legislation is territorial in nature. So, unless it is clearly said or understood from the legislation itself that extraterritorially it can be applied, it becomes difficult. So, that is a challenge which with regard to the rights framework you have both at the international level and at the domestic level. But there is another dimension, of course, this is happening as part of the investment related arbitration issues, is that there is an argument that states should have investors should respect human rights obligations which are part of international law as well as the domestic law of the countries where they invested. But it is a very tricky issue. People argue that many a time the investment arbitration, when it takes place, they purely focus on the investment related to international law, that is, could be a bilateral investment treaty. They do not go into the applicable law part of human rights. So, it is more seen as a kind of a law that is not applicable to this arbitration tribunal. So, those who are into this field argue that this kind of challenges are there as part of the investment arbitration part. So, it is as part of the legal framework, these are the challenges which, now that is where the question comes in, is that why globalization process, which probably arguably considered as a kind of a positive impact on certain fields, is not having same impact on other dimensions like rights framework. So, yes, that is a challenge which needs to be addressed as part of the larger globalization process.
Yeah, so it is interesting to note that why these investors do not give due regard to the human rights. So I was also wondering on the same line. So now if you look at the bilateral investment treaties framework, they are mostly into giving protections to these investors. You will see them rights against expropriation. It will contain a right against right in favor of fair and equitable treatment, right against anti-discrimination. So is it possible that we should also include provisions with regard to human rights as a part of bilateral investment treaty to make them respect the human rights and not ignore them?
Yes. Probably I think there is a kind of a resistance that happens because it is bilateral, so they are not multilateral. So many other factors work when two states enter into a bilateral agreement. Many things may not be discussed which probably would have been possible in a multilateralism. But there is an attempt by those who are very much concerned with human rights in terms of bringing in that certain obligations for corporate entities in the form of a business and human rights. So there has been a work at the international level. As a result of this work, in 2011, Human Rights Council has accepted the business and human rights guiding principles, which works predominantly, as I discussed in my lecture, that it has a three-pillar mechanism where this protection, respect and remedy framework this works. So there is a serious attempt now to make a kind of legally binding international treaty with regard to business and human rights obligations. So there is an effort basically to impose certain human rights obligations on corporate entities wherever they work especially. So if it is not possible as part of the investment regime, probably this kind of a multilateral mechanism might have might succeed in terms of putting certain obligations on the private corporate entities when they engage in business activities outside, wherever or across the world.
Okay, so I'm prompted here to note that on the other hand, in 1990s, the OECD tried to come up with a multilateral agreement in investment, and it failed only because its lack of concern for human rights. So now, in your previous video, you'd also mentioned about the rights of indigenous people. So can you tell us something about how the globalization has impacted the rights of indigenous people?
Yes, now this aspect is where you do not find a kind of a, in relation to indigenous people, there is no legally binding as of now international treaty, but there is a declaration on the indigenous people. Now there are several issues involved in it with regard to indigenous. Who constitutes indigenous? There is a one argument to say that there is some purely the indigenous people exist only in relation to settler colonialism, where the colonialism went and settled there like Australia, Canada, United States and New Zealand. So therefore, whether indigenous people exist in other parts, the broader understanding is that indigenous people are those which in South Asian context we refer to as the tribal communities. So there is a challenge with regard to what constitutes the indigenous community or indigenous people in a collective sense. That is one aspect of it. The other dimension is that they have a very kind of an interesting or a peculiar relation with what constitutes as a development. At many places, the indigenous and tribal community, the notion of ownership is collective, not individual. So the general understanding is that most of the rights framework develops on the idea of private property. So the private property argument is, for example, my land is acquired by the state under the concept of eminent domain. That is a concept which was developed by, is coined by Hugo Grotius with regard to the state has the power to acquire the property of the private individuals without getting into the transaction, market transaction, because the state would be working for the public good. So when that happens, the private individuals can claim compensation from the state because I have ownership on the land or the property. But what happens with indigenous or tribal communities that they do not have an individual ownership. So if they are enjoying the resources of the forest, or if they are enjoying the resources from the land with an understanding that collectively they own it. So when the state acquires it, now there is a challenge for them that how do they claim legally the compensation, because they really do not own the land. So they are very specifically in a peculiar position they are placed. The other dimension is also the cultural identity part of it, which can be seen as a cultural rights framework, which for a longer period of time they maintain their cultural identity, their whatever the framework they live with, or a social cohesion that they live with. Most of those things get disturbed by this what you call as a development agenda, which we go with, whether in the name of globalization, even otherwise. So from the point of view of indigenous and tribal communities, the general framework of rights sometimes finds itself inadequate to address their concerns, and there is no effective legal mechanism, at least at the international level, and more or less that is the case with most of the domestic systems also. You do not take into consideration of their identities. Many a time we go with the agenda of development, agenda of modernity, which there is a kind of where there is a kind of friction happening between their identity and their understanding of what constitutes development and the modern agenda of development, and the friction that takes place between these two worldviews, you can call it. Yes.
So this is not something that's happening very far away. So we are now sitting at Cuttack, and few thousand kilometers from here we have Niyamgiri Hills, which is considered to be the sacred hills of the tribal communities living there. And when there was an investment plan of Vedanta setting up an plant here, that there was a huge cries that we've seen the protests very closely. So how do you think who should address this issue? Who should protect the rights of indigenous people?
Yes, that is it's not an easy question to answer. One is that when we speak in terms of rights, we are focusing more on terms of legal rights, for which there has to be a remedial mechanism to it. But the kind of a development agenda in the name of globalization is happening, is arguably being seen as a kind of a progressive thing to happen. In a positive sense, it is benefiting the people. But on the ground, the reality seems to be that it is not really reaching everyone, or at least some are being left out of this whole process. Now, how it has to happen? Because it happens through complex legal framework, as you rightly pointed out with regard to how the investment framework works, how the multilateral trade system works, and the human rights on the other side. So, and it is a weaker system which is evident from the institutional and legal mechanism that we have to have. So, it has to happen at multiple levels. It is not that something that one level, at a local level it only happens, but the decisions are being made at the international level somewhere. So, there has to be an effort to engage with what is happening at the international level, to gaze as to what exactly its implications would be and respond to them when the policy and the law is being made at the international level, and also need to put certain amount of pressure, state as an entity, which, because at least traditionally, even assuming that the globalization would like to emphasize less on the state and state machinery, but for the purpose of rights framework, state still remains as a central player. In the rights language, when the rights violation takes place, now the remedy has to primarily come from the state. So, therefore, even assuming that the process of globalization is more in terms of emphasizing less on the state and the state institutional mechanism, but for those who get affected with this process, I think still state remains as a significant player in terms of remedying the rights of the individuals. So, therefore, I think state still holds an important role to play, even assuming that what you call as a process of globalization where state should play a lesser role, but from the rights point of view, state has a significant role to play in protecting the rights of those who are marginalized and subaltern classes.
Now that you brought about the role of state in protecting the rights of the indigenous people, I was wondering, shouldn't the state do something about the potential violations or the impact on human rights at the time of screening of these investments? And most often what happens was, when they allow the investments to take place and then later on they realize about the potential violations, or actually after the violations has happened, when they ask the investment to take back, that there is a good chances that they might get challenged before investor state arbitration, and they this host states end up paying huge amount as penalty after they lose the.
Yes. Now, generally this question repeatedly comes, that because when you enter into international law, you are a sovereign entity, you can exercise your sovereign power, and international law works based on consent. Therefore, unless the state expresses its consent, there is no obligation that would come from international law. So, why states don't do that at the time of accepting international obligation? Now, what needs to be understood is, I don't think this consent works exactly in an objective, neutral manner, because the consent can be worked on in the sense that the state can give consent through various other means also. So, therefore, even if it in a formal sense it is a consent based mechanism that you enter into international obligations, but before that several other factors work, larger economic and political part. So, it is not purely the state's will that through which they enter into obligation, because other factors also, both political, diplomatic issues involved in it. So, after that then other implications would come in. Once you accept the obligation, then it leads to litigation, it arbitration. So, states also work under a particular, what you call as a pressure. The pressure, I do not say that it is because some states comes and says that I am going to go against you with the war, we are going to wage a war against you, therefore you have to sign a treaty. It does not happen. I am not saying that it happens that way, but there are various other political and economic, geopolitical situations that influence a state or compel a state or make a state to become a party to an international treaty or not to become a party to an international. So, that challenge is there, because from the point of view of a state, one also has to look at how certain states, are mostly developing countries, are constrained to act in a particular way in particular field. So, that challenge, that needs to be appreciated. Therefore, we need to understand what happens behind the lawmaking process. That is equally important. The formalistic understanding of lawmaking may not help us much if you want to address it in a comprehensive sense.
Okay, so now at the end of our discussion, is it safe for me to conclude that we need to somehow find a balance between the development agenda vis-a-vis the human rights framework, and somehow I feel that the human rights framework has been neglected and it's been at the lower end of the bargain between this?
Yes, that needs to be taken into consideration. If go by the argument that globalization works in a positive sense, but at least there are examples to show that it does not always work in that manner. So therefore, those factors, especially at least from the point of view of rights, I am not saying that once you address all the rights in an effective manner, that is going to solve all the problems. No, but at least the rights framework has in certain respects implications in terms of putting certain obligations, those who go for investment, development, and also on the state. So therefore, yes, rights language should get into the development argument part of it, so that the evenness, the results of the development evenly get distributed, and in which still state plays state as an entity plays a significant role.
Thank you, Dr. Srinivas, for such an insightful discussion on the impact of globalization on human rights. So this ends our panel discussion, learners. We hope that there is a shift in human rights paradigm where we effectively challenge the negative consequences that have been brought up with the development agenda with the advent of globalization. Thank you.